Happy Monday, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about contract law. Cases that should have gone to the Supreme Court of Canada, but didn't. Specifically, in a really boring contract related to energy, uh, the parties argued that their intentions during negotiation overwhelmed the explicit language of the contract. And the court disagreed and found that the intention of the parties, even if it's contrary to explicit language of the contract, cannot alter the language of the contract. This is a very important issue that the Supreme Court of Canada should have taken on. People enter into contracts every day, all day, every day, oftentimes not even knowing they're entering into contracts. And so when it comes to the law of contract, because you don't just have to have an agreement in words, because there are, very little that is required to actually make a contract, it would be important for the Supreme Court of Canada to talk about the way in which intention changes the analysis of the terms of the contract. While obviously a written contract is meant to provide certainty for the parties, if the surrounding correspondence or choices that individuals made as a result of the contract are impacted by those discussions and the contract doesn't accurately reflect somebody's views, shouldn't there be some avenue for consideration of that? Especially because when dealing with contracts, there is often a power imbalance. There's a party who's usually the person drafting or providing the contract, and the person who's signing it is usually a person who needs or has a desire to accede to it. So in those circumstances, intention should form part of the consideration. And yes, this may lead to more contract-related disputes in court because of the question of intention, but courts are very easy to deal with the evidence. We've seen cases where a thumbs up emoji was enough to constitute a contract and for the parties to have understood what was going on. And so it's not as though trial courts are ill-equipped to deal with this. Unfortunately, the Supreme Court of Canada, I think, failed to recognize the way in which the law of contract is quite antiquated with respect to the way that we actually operate our daily lives and the way in which we now engage in contracts throughout the day. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.